Hello, welcome everyone. It's my pleasure to welcome Dr. Sharon Thompson as our guest lecturer for International Women's Day. Sharon's paper is on feminist legal theory and the case of divorce. Sharon is a reader in the School of Law at Cardiff, but she has got a very special place in our heart at Keele because her journey started with her lectureship here with us. And Sharon is an internationally recognized expert in family law and feminist legal history. Her monograph on prenuptial agreements was shortlisted for numerous book prizes and also has been cited with approval by the High Court of Australia. Sharon is the holder of an Outstanding Contribution Award for Research and has been interviewed in various platforms, including the BBC. And she has been invited as an expert in the BBC Radio 4 programme, The Battles That Won Our Freedom. So over to you, Sharon. Thank you so much for being our guest lecturer.
Thank you so much, Eliza. What a lovely introduction. I do wish it were in person. I have such great memories of my time at Keele, and thank you so much for giving me the chance to speak a little bit about feminist legal history too, as it relates to my current research. I'm currently on study leave at the moment, writing a book on the Married Women's Association and its efforts to reform different aspects of family law. So the Married Women's Association is a group I stumbled across really when trying to find out a bit more about a fairly arcane statute called the Married Women's Property Act 1964, which they turned out to be involved with. And as a family lawyer, I simply had no idea really what this group had done for family law in the mid-20th century. And I think a few other family lawyers probably feel the same way. So I became interested to find out more as to why this might be the case. So feminist legal history, I would suggest, is a tool that can definitely help with this, because this approach shifts focus away from dominant narratives about the laws that passed and those who were successful in achieving reform to look instead to those who have influenced change sometimes in an unforeseen way, perhaps behind the scenes. And of course, change can be influenced by the bills that were not passed, the people who were not successful in achieving their aims. And I definitely recommend Eric Arackley and Rosemary Archimedes' latest article on this on feminist legal history, almost as a sort of guidebook on how to use this approach. And it just came out recently in the Oxford Journal of Legal Studies. Feminist legal history for me has helped frame my own research questions to look at women's relationship with law and law reform, and to seek out accounts that look to the roles and experiences of women and feminist work. And this makes accounts of law reform arguably much messier than they might first appear because of the broader feminist context of the campaigns, the setbacks, and when there is success, the backlash. It also requires looking to non-legal sources to learn more about the previously ignored legal actors. So I am adopting this approach today, and I am going to focus not on the Married Women's Association, but on their first president instead, Dr. Edith Summerskill, and what her role was in divorce reform in the 1960s. Which I'm pleased to say will be published in an article in Child and Family Law Quarterly later this year. So Edith Summerskill, she was a doctor, she was a politician and a feminist activist at a time really when women were only just allowed to participate in public life. She was a Labour MP from 1938 until she became a life peer in 1961. And by this time there had only been 3 other female ministers of state. Summerskill had a track record for fighting for women's rights because she masterminded the Married Women's Property Act 1964, which gave wives a 1/2 share of housekeeping savings, and also the Matrimonial Homes Act 1967, which gave deserted wives the right to occupy the matrimonial home. And her grandson, Ben Summerskill, when I interviewed him for my book, told me that as far as he is aware, she was the first woman politician who happily called herself a feminist. So Dr. Edith, as she was known to her constituents, is often described as formidable and redoubtable. She battled priests on the election trail in the 1930s when she refused to tone down her pro-birth control stance. She tried to ban boxing, and she spent her entire professional life devoted to the work of the Married Women's Association to try and establish an equal legal and financial partnership within marriage. But to try and give you a sense of what she was like, I want to share an anecdote taken from Patricia Hollis's 1997 biography of Jenny Lee. In it, she writes about journalist Melanie Phillips, who went to Edith Summerskill's house to try to interview her for a book. And she was invited in by Summerskill mistakenly because she thought she was someone else. So, quote, "Upon discovering this, she inquired what I had done for the feminist movement. I replied I had done nothing of any significance. She seemed much taken aback by this information. Well, what movements did I belong to then? None at all, I replied. None at all? How old was I, and was I educated? Upon learning that I was 27 and had been educated at Oxford, she drew herself up in her chair as if I had delivered some savage insult. Did I not know who she was? Did I not know that she had spent years of her life working so that girls like me could go to Oxford? And what was I writing this book for anyway? Just out of interest, I replied feebly. Interest, she exclaimed. I was obviously writing it for the money. She had nothing in common with me, she would tell me nothing, and thought I had better leave. Within 10 minutes of meeting Lady Summerscull, I found myself on the other side of her front door." So now we know Dr. Edith a little better, I want to talk today about her role in reform of divorce and its financial consequences in the 1960s. As you can see on this slide, the most recent reform of divorce was last year, and this will come into effect later this year. And it removes fault from the divorce process entirely, an important and radical development in family law since the concept of the matrimonial offence has overshadowed secular divorce law ever since it was first introduced in 1857. Now, the last time divorce reform was introduced was 50 years ago in 1971, when the Divorce Reform Act 1969 came into force alongside significant reform of the financial consequences of divorce too. And it is this landmark reform that I want to focus on in this talk. I want to note two things in particular on this slide. First is the fact that the implementation of the Divorce Reform Act was delayed until 1971, so the Law Commission could properly investigate the financial impact this would have and propose reform accordingly. Second is the quotation at the top of the slide here, that in 1982, feminist historian Dorothy Stetson said that originally the Law Commission did not plan to recommend reform of the financial consequences of divorce until later down the line. So if you're like me, this would be immediately, ringing alarm bells. Do we know the whole story of why the 1969 Act was delayed for 2 years at the 11th hour? And if Dorothy Stetson is correct, what changed the Law Commission's mind? I'm going to argue that feminist legal history helps answer these questions. There's obviously no straightforward answer to this, but I'm going to make some suggestions that relate to Edith Summerskill and the work of women's pressure groups like the Married Women's Association, which she was, of course, connected to. So we start to get some insight into this when we look to alternative sources that might not be immediately obvious when doing legal research. So I'm not talking about Law Commission reports, textbook histories and the like. I'm talking about archival documents, memoirs, diaries and letters. What's the unofficial story? What's going on behind the scenes? Looking at MP Leo Abse's memoirs, who was a staunch advocate of divorce reform at the time, he makes an arguably surprising admission. It was a real wonder the divorce bill ever reached the statute book, he said. No one was more successful in delaying its passage and in arousing hostility to its objectives than Edith Summerskill. So what was her problem? Well, the superficial historical account begins and ends with the explanation that Edith Summerskill opposed the Divorce Reform Act because she said it was a Casanovas Charter. This was because part of the reform introduced was divorce without the consent of the respondent spouse after 5 years separation. So Summerskill's Casanovas Charter worry was that the Casanova, the philanderer, could run off with another woman and desert his wife. Now, ostensibly, Summerskill's opposition seems conservative. It was 5 years separation after all, especially given also that when the reform was introduced, women were statistically more likely to petition for divorce than men. And that's certainly how her role is depicted, when it seldomly is, in family law textbooks. But Casanovas don't bother with charters, Lord Stowhill said at the time in the Lords. If husbands want to leave their wives destitute and move on to a younger woman, they don't need divorce reform to do this. However, importantly, it was this Casanovas Charter opposition that helped make clear something needed to be done about the financial side of divorce. So, should her view be dismissed as an odd brand of feminism, as Leo Abse said it should, or does taking his perspective mean we are missing an important part of this moment of family law history? As you can see here, Abse claimed to not understand her point of view at all. He's not understanding how she could be a feminist and imply that women needed protection from divorce. And Baroness Gateskill said that Summerskill's view was tantamount to leaving a wife in her, quote, gilded cage with an unloving husband. Is that what an emancipated woman wants, she said in a House of Lords debate. I am shocked and surprised at my noble friend Lady Summerskill, who is a great feminist and who has done so much for the women of this country. She wants that woman to sit there, to sit in the house, to sit in her home and wait for her pension. Surely any woman with spirit would hate to do that. So you can see where Summerskill's view was seen by some as outdated and was also dismissed. However, already we can start to see the other side of this criticism when looking at the letters that Summerskill was receiving from women at the time who were worried about the reform. So if we take this letter as an example, the woman is writing, it is all very well for Lady Gateskill with no financial worries herself to blithely say that the Social Security will provide under the new divorce bill. Taking all of this into account, I want to argue that Summerskill's view is misrepresented by the Casanovas Charter soundbite. Her role in delaying divorce reform was important because it played a part in allowing radical reform governing the financial consequences of divorce to be introduced. And so crucially, I want to argue that Edith Summerskill did more than simply condemn Casanovas. She gave voice to deserted wives by fighting for their financial protection. And dismissing her argument has arguably led to dismissing Summerskill's viewpoint entirely, meaning that the story behind the Casanovas Charter soundbite is lost. So for the rest of this talk, I will first look into what Summerskill's concerns for divorce reform were in more detail, and will then look to what she thought should be done to reform the law. As I've already mentioned, a great source for learning more about this is the archives and the letters that are in the archives. I studied a sample of 283 letters that Summerskill received from women worried about divorce reform that were in the closed files of the Women's Library at the LSE with special permission from the library. And the sample of letters I studied revealed that middle-aged women who otherwise felt invisible in the eyes of the law and politics viewed Summerskill as their advocate. I do want to write and say how much I appreciate all you're doing to help women of my age, wrote one woman, with another saying, I have such faith in you as our best ally, and another, we rely on you. So Summerskill, she's aiming to give voice to these women, typically over the age of 40, when their stories and their experiences would likely otherwise be unheard. And Summerskill clearly thinks that this is the case. that they were unheard. If we look at this extract, for example, in the Lords, where she is opposing divorce reform, you know, she's saying the Lord Chancellor has told us that there's a consensus of opinion, and he's mentioning the Church of England, the Methodist Church and the Law Reform Committee. But these are organisations composed almost entirely of men. Yet Summerscull repeatedly argued that the proposed reform would be disproportionately harmful to the middle-aged and the older women, and their experiences were not being understood. And as she put it, divorce without consent was opposed by every women's organisation in the country, and they, as we know, are not represented in this House in great numbers. Now, as you can see here on the next slide, she was not the only one. Of course, Lord Simon, who was president of what became known as the Family Division of the High Court, was also very concerned. And here he has written a letter to Edith Summerskill. It's arguably quite a remarkable letter, because the other letters he had sent to her that are in the archives were typed on A4 paper, and they were all signed quite formally, J.E.S. Simon. But here, this one's different. It's handwritten on small note paper. And he has written to Summerscull that it is not too soon to start mobilising the women's organisations. Married women are in grave danger, he said, and after all the disreputable agitation in favour of the divorce bill, the promoters are likely to be held in restraint only if it is seen that the passage of the bill is likely to be highly unpopular. So at this point, it's apparent that those opposing the bill, or some of those opposing the bill, including Summerscull, are not against divorce per se. They are worried about the economic vulnerability of the woman left behind. They're using the Casanovas Charter soundbite to stir up feeling about this. Because marriage, of course, is a very different beast in the 1960s, and obviously, although increasing numbers of women were entering into the workforce, this pattern of the traditional breadwinner, homemaker, was still very common, and without proper legal recognition of women's work in the home, housewives in particular were made dependent because of the social structure of marriage, and as a result were more vulnerable on divorce. And at this time too, courts had limited ability to redistribute property. Married women had some rights of occupation of the home thanks to Summerscull's Matrimonial Homes Act, but overall the financial consequences of divorce were governed by a series of patchwork and mostly ineffective remedies. So Lord Simon was not overreacting when he spoke of the grave danger women were in, and you just have to look at the fraction of the many letters that Summerscull was receiving as an example of this. So here's an example of one of them, where this woman is writing, "I am a terrified lady of 67 years. My husband left me some years ago for someone younger. In several occasions he has returned to me but has gone back to the other woman. To provide for her, he now wishes to divorce me under the Divorce Reform Act so that the widow's pension will go to her, his admitted sole reason for seeking a divorce. So if he died, the widow's pension, he would say, would go to his new wife and not to her. I make my ends meet by working in a full-time job, not well paid because I am untrained and started late when I was left alone. It has no pension. In due time, because of my age, my employers will put me out to grass. When that time comes, the widow's pension, the pension she would get from her husband, will pay my ever-rising local rates and provide warmth and necessities. Without it, I must give up my home, and I am terrified at the prospect of being without a roof when I shall need it most. To have this linchpin abruptly removed, as it will be by the Divorce Reform Act, is surely against all justice for the elderly wife. We are now too old to make alternative plans, and without these pensions, sufficient means to keep our homes will vanish." And as I say, there's loads of letters like this. This is just another one. You know, I do not exaggerate when I say that my husband left me ill, penniless and homeless. I'm 58 and it's not easy to find work at my age. It would appear that a person in my position has no rights at all. So it was serious. Women were at risk of being made homeless if something wasn't done about the financial consequences of what was going on. Now, Summerscull suggests there is a solution, and she suggests this in the same speech in the Lords where she calls divorce reform a Casanovas Charter. So she quotes her ally, Lord Simon, the one who wrote the letter in the previous slide, where he said in a quite famous speech in 1964 that the cockbird can feather his nest precisely because he is not required to spend time sitting on it. And Summerscull then says in the Lords, this being so, a separation of goods between married people cannot be said to do justice to the wife. In other words, by not giving the wife any legal interest in her husband's earnings, the law is failing to recognise the fact that she helped earn that money through her unpaid labour. So here, Summerscull wants women's unpaid labour to be recognised in economic terms, for spouses to share the financial fruits of the marriage when it dissolves, and this argument sits at the heart of her opposition to divorce reform, and it relates also to the letters she had been receiving at the time. In these letters, as we saw in the last couple of slides, women are describing a range of personal and individual experiences, but the fundamental problem in each of them was financial. As one letter objecting to divorce reform put it, the money question is serious for a woman with children to bring up alone. The bill will create a new poor in our welfare state. So for this reason, the significance of the delay of the Divorce Reform Act to facilitate sweeping form of financial remedies shouldn't be underestimated. Note also that Summerscull is talking about the need for a matrimonial property law, which includes community of goods too, towards the bottom of the slide where she's talking about Casanovas Charter. So, you know, if you're going to have a Casanovas Charter, then you need this new matrimonial property law to come in, is what she's saying. It appears here that she's actually referring specifically to a bill that was engineered at that time to slow the passage of divorce reform, which is arguably another neglected part of the story behind all of this. And this is what I want to look at next. So this bill is the Matrimonial Property Bill 1969. It's another fairly arcane but quite important stumbling block that was, as I say, slowing down the implementation of divorce reform. Potentially an even lesser known aspect of the bill is that it actually originated from discussions with the Married Women's Association over joint ownership of the matrimonial home. So the Married Women's Association had its own matrimonial property bill. This is what it looked like alongside its explanatory guidance. So it stimulated these discussions, and as you can see, it sought to build upon the Matrimonial Homes Act 1967 by not just having giving married women a right to occupation of the home, but by also extending that so that both spouses would have a proprietary interest in the home regardless of whose name was on the deeds. So this stimulated discussions in particular with an MP called Edward Bishop, and he ended up coming third in the private members' bill ballot. So he is able to introduce a bill related to matrimonial property. He then goes to legal academic Olive Stone, who, as an aside, was the first woman to work in the law department at the LSE. And she gives him assistance in drafting the Matrimonial Property Bill 1969. Now, the Bishop Bill went further than the Married Women's Association's bill. It went further than joint ownership of the home, and it provided for the equal division of all property acquired during the marriage, excluding property owned at the time of the marriage or obtained through gift or inheritance. So it was a form of community of property that was being proposed, a kind of deferred community. Ultimately, however, Bishop withdrew his bill and it never became law, but it was quite popular at the time, certainly in the public domain. After it successfully passed its second reading in the House of Commons, despite criticism from every lawyer who spoke in the debate, Bishop made a deal with the government, agreeing that if the Law Commission could draft a better bill, the government would give it time and it would pass. And this is what then paved the way for the Matrimonial Proceedings and Property Act 1970, which was the statute that brought in the wide-ranging discretionary powers to make financial orders, including the redistribution of property and divorce, as we know it today under the Matrimonial Causes Act 1973. So as a result, the Bishop Bill then proved to be a suitable delaying tactic to ensure divorce reform was not passed without reforming divorce's financial consequences. And interestingly, correspondence between Bishop and Summerscull also provides new evidence suggesting their collaboration in these reform efforts and of Bishop's feelings about his strategic compromise with the government. So this is a letter that Edward Bishop wrote to Edith Summerskill about it. And it's on the right here, but I've tried to highlight some of the interesting parts of it. He's thanking Summerscull for her work here, and he's explaining the deal and the compromise. It might not have been exactly what they wanted to achieve, but it helped pressurise the government into pushing through reform of financial provision and divorce, in his view, in this letter. And I think this is so interesting to see, because in textbook accounts we learn that the Law Commission was responsible for recommending this reform, which is true, but we don't see the pressure they were put under by other groups behind the scenes to make these recommendations. As Dorothy Stetson argued, the Law Commission very likely took the debate on the Bishop Bill into account when preparing the 1970 reforms. Yet Summerscull ultimately felt the deal to withdraw this bill was a confidence trick against the women of this country, because like other pressure groups at this time, she was angry that there was no new law governing property ownership during marriage. And as you can see on the slide, Olive Stone, who had helped draft the Bishop Bill, was also very frustrated. And she writes in a letter to the Council of Married Women, which was a breakaway group from the Married Women's Association. My own impression is that we shall delude ourselves if we think that the Bishop Bill had done its job. It has raised a real and substantial point, and the judges have shown since that they largely agree with its aims. But property is the holy of holies. If women want it, they will have to go in and get it. Nobody will offer it to them on a plate, but all sorts of smoke screens about bad drafting and the like will be raised to head them off. I hope they will keep on target. And I suspect Olive Stone here, in the reference to bad drafting, is also talking about the accusations that were made against the Bishop Bill that she helped draft, which was that it was very, very poorly drafted. On the other hand, without the pressure exerted by the Bishop Bill, the implementation of property reform and divorce would have been much more difficult. And this reform is what underpins our system of financial relief today, allowing the judiciary to adjust property in a way that gives credit to the contributions made to caregiving and domestic work in the home. Yet this alternative account indicates how close England and Wales came to something much more radical than the law that we have now, a new law of family property. The Bishop Bill is the closest England and Wales has ever come to accepting community of property. And though it didn't pass, it has an important place within the history of the 1970 reform because, as Stetson has pointed out, it forced elites to include additional safeguards for married women's protection, and without it, the implementation of property reform on divorce would have been much more difficult. So that's the side of the story of divorce reform I've been able to uncover by taking a feminist approach and by looking behind the scenes and to alternative sources. I hope I've persuaded you of the benefits of this approach to legal research. I've certainly found it an exciting way to revisit dominant historical accounts. In the case of my research on divorce, a feminist approach arguably shows why examining Edith Summerskill's view is important historically, that Summerscull identified as feminist and represented older women typically not involved in the women's liberation movement at that time provides historians with an opportunity to explore the spaces between dominant discourses surrounding divorce reform in the late 1960s. And she was criticised for her view by commentators such as Carol Smart, who rightly argued that Summerscull identified women's economic vulnerability within marriage, but did not identify the institution of marriage as the problem, which went against the grain of second wave feminist thinking at that time. In representing the concerns of deserted wives in the face of divorce reform, Summerscull was treading a delicate balance between advocating for their protection without reinforcing the gendered and stereotypical position of the vulnerable housewife, and her critics argued that she didn't necessarily do this successfully. Nevertheless, an alternative view that focuses on the reality of women's structural inequalities in marriage is something that feminist scholarship has of course long sought to redress and is not inconsistent with Summerscull's argument either. Political and legal rights such as access to divorce could create opportunities for women's integration in society in the 60s, but to take advantage of such opportunities, women needed to be able to access resources. And this experience of structural inequality was pervasive in the letters that Edith Summerskill was receiving. Non-legal sources can also help produce an alternative account of processes of reform, which is sometimes dismissed as technical detail, but in fact helps legal historians to better understand how policy and law is reformed. To look not only to the statute that passed, the principle that succeeded, or to any information that does not fit the chosen legal narrative, but to go beyond that and see what else is behind the scenes. Thank you so much for listening. I've included some details of relevant forthcoming publications just in case this is of interest.